jurisdictional point is, by definition, your right of appeal is automatic. And there's nothing the judges can do about it.
How do lawyers win on winnable cases?
You know, I think a lawyer's starting point is not to determine whether a case is winnable or unwinnable. That is the job of the judge. It's the judge that determines whether a case is winnable or unwinnable. But, you know, having said that, I think the primary function of a good lawyer is to give good advice. So if you give good advice, you obviously, that advice will be based on your assessment of the facts and of the law. And I think lawyers who win most of their cases, it's because they would not prosecute cases that are not winnable. It's not every case that has to go to court. And I think that, you know, good lawyers, their clients value them because they stop them from engaging in frivolous litigation. So how lawyers win what appear to be unwinnable cases, in my view, is by not taking those cases to court in the first instance. Addressing that question, when you say how do lawyers win unwinnable cases, let me give you a factual scenario. Mr. A has borrowed money from Mr. B. There is a signed agreement. So there's no dispute that he borrowed the money. There's no dispute that he has not paid. There's no dispute that Mr. B has demanded the money. Now, if Mr. B demands the money, but then, you know, relatives, friends get involved, they intervene, they're discussing, oh, don't do this, and he allows himself to be persuaded not to pursue a claim to recover that money for a period that exceeds the period provided in the statute of limitations, that claim becomes statute barred. Now, to the lay person, this is an unwinnable case. You borrowed money, there's no doubt that you borrowed money. But then to a lawyer, yes, you borrowed money, but then the claimant should have brought this claim within 3 years, which is what the law provides. So, yeah, you know, morally, it's wrong for you not to pay what you borrowed, but legally, you actually have a good defense to this claim. Your defense being that the claim is statute barred. So for a lawyer, you know, for a lay person, that claim is unwinnable because there's no dispute. There was a loan and it hasn't been paid back. But a lawyer would look at the facts and look at the law and see if there's any aspect of the law that can be used to vindicate his client's rights.
Adjournments appear acceptable in our judicial system, which encourage delaying tactics.
Adjournments in themselves are not a problem. It is the manner in which our system enables adjournments to be sought and to be granted. And you know, when litigants ask me how long do I think a case will take, I always tell them about this. There's a tripod in my mind when I consider litigation, assuming that there are only two parties. So there's the plaintiff, the defendant, and the judge. And I think that if you have two of those who want to deal with the case efficiently, even in our environment, there's very little that you can do to stop them from dealing with the case efficiently. But if you have two who are not interested in efficient treatment of the case, then there's very little that the lone man standing can do. So I'll give you an example. A litigant doesn't want the matter to progress and he brings a frivolous application. The judge also is tired and overworked. He's going to grant an adjournment on the flimsiest excuse because the litigant has just given him an excuse to go home early, you know, or to go into chambers and write, you know, deal with the backlog of rulings that he has. But if you have a judge who's willing to progress the case and you have a litigant who's willing to progress the case, it becomes very difficult for the party who is seeking to delay to consistently get away with it. So, I mean, I'll give you another example. A litigant comes to court and says, oh, my car broke down, or my wife is ill. Now, maybe he's looking for an adjournment for 6 months. But a judge who's serious about the matter will say, okay, come back tomorrow. I'll give you one chance, come back tomorrow. But if you're not here tomorrow, I'm going to go ahead with the case. Now, that is the way in which, you know, justice can be delivered efficiently, even in our system. So it's not to say adjournments are not bad, because sometimes adjournments are actually justified. I mean, if a lawyer stands up in court and says he's ill, you can't really compel him to go ahead despite his ill health. But then you can take steps to ensure that that doesn't become a repeated tactic. What you have in our system is that cases are dragged out for years Today he's ill, tomorrow his mother is sick, the next time he's burying his father, and on and on and on. And it's only an inefficient system that allows that to happen.
So what do you think the solution is? Talking in terms of accountability of the lawyers on the one hand and the judges on the other.
I think the solution is a holistic approach to reform of our entire system of adjudication. And I know that that effort is ongoing as we speak. There's a body of very senior distinguished lawyers that has already come together and that is engaging with government at the highest levels with a view to addressing this problem. I don't have the mandate to elaborate on, the details of what is being done, but the focus right now is on pushing legislation that will empower the courts to be a bit more dynamic in managing the system, and that will also impose proper sanctions on lawyers that take advantage of the gaps in the system to create this delay. But as I said, those are just two aspects of the problem. I think a third and very, very significant aspect of the problem is the process by which our judges are selected. Because if you don't have judges with the right capabilities and the right capacity in place, this problem will not go away. So the process of selection is critical. Two, the resources that are put towards the judiciary, the number of judges and how they're remunerated, they need to be encouraged because it is extremely hard work. I think all those things need to be looked at together. And if you look at the amount of money that the third arm of government, that our legislators go away with for part-time work, I think that really our judiciary is extremely, extremely underserved, and that is part of the problem.